What's up, guys? Brian Fellow Law Group PLLC here with your Florida Law Weekly case update. I got 4 cases for you. It's Monday, but that's okay. We're going to get through this week together and on a great start with the Florida Law Weekly case update. So, 4 cases. The first one does not have to do with family law, but I thought it was kind of funny, actually. It's a little, depending on your humor. This has to do with a case where a teacher was reprimanded for certain social media posts that he put on his Facebook account. I think this was back in 2020. And I'm assuming this guy was probably some sort of Trump supporter, not a Bernie Sanders fan, that's for sure. One of his posts was a repost from a Facebook entity called Messenger of Liberty, which stated as follows, quote, "My son is taking part in a social experiment. He has to wear a Bernie 2020 t-shirt for 2 weeks and see how people react. So far, he's been spit on, punched, and had a bottle thrown at him. I'm curious to see what happens when he goes outside." I mean, come on, that's kind of funny. But I mean, politics aside, hey, I don't harbor any of those views. That's just a funny post in my opinion. But he had some other ones that were kind of, they were more risque and they were like totally not appropriate. But they were on his private Facebook, or what he thought was his private Facebook. And so he was suspended and reprimanded, and he sued, and he actually won. So there's a two-part test for teachers who post things online. It's basically, is the post a matter of public concern? And so here his posts, yes, they were a matter of public concern because they had to do with the 2020 election. And then number two, did they have some sort of disruption in the workplace? And the court found that really no, they didn't really have any actual disruption, or at least there was no evidence presented that would prove that they had some sort of substantial disruption to the workplace as a teacher. So he was able to get his reprimand tossed out and his suspension overturned. So I thought that was a funny case. You can read some of the remainder of his tweets in the actual case. But anyway, so next case is Reed versus Reed. It's a fourth DCA case, back to marital and family law. This has to do with unequal distribution, so that's one thing. This case was one of those unique cases where we don't see them that often, where there's actually unequal distribution. So this was an 80-20, 80%, 20% unequal distribution of the party's main asset, which was their property. So they had a real property and must have had like I think it was 20 acres or something like that. It was a large property, and they operated a business on it. They operated a B&B, bed and breakfast, and originally they bought it. They were going to do some sort of thing with parrots. They had a bunch of parrots. They actually had like $150,000 worth of parrots, birds. Anyway, so what happened here was they split, they separated in 2000. So before 2000, they were sort of contributing jointly from a joint account to pay for the expenses for the property. After 2000, husband split, went up to, I think it was Michigan or something like that. He moved away, and so the wife was left there to operate the B&B on her own. And so from that point on, she paid all the expenses. She paid the mortgage. She paid all, like I said, all the expenses for the property. And so the wife's forensic accountant came up with a formula where basically she did a proportion of the amount that they spent for expenses prior to 2000 when they split, and then after when they split. So they found that it was an 80-20, 80%, 20% split. And so the court awarded the wife 80% of the asset. Now, what the court did wrong, trial court, was it awarded 50% of the liabilities. So that really wasn't fair, because that counts as an unfair deduction, a credit to the wife, where she gets 50% of the liabilities and mortgages, but she gets 80% of the assets. So the court said that was reversible error. So reversed to equate the liabilities with the percentage of the assets, the 80-20 split. Now, the other thing that I thought was super interesting, and this is something to consider. So the trial court considered the effect of taxes on the sale of the property. And so the court said that was okay. You're allowed to consider the effect of taxes on the sale of a property, even though there was no contemplated sale whatsoever. But the court is not allowed to consider closing costs on a purported contemplated sale or potential sale when there is no actual contemplated sale. So it's sort of like they treat two different types of expenses that would only occur on the sale of the property, but they treat them differently. And that's because the statute specifically requires the court to consider the tax effects on distributed assets, but it doesn't allow the court to consider closing costs on something that didn't actually happen. So kind of weird, treatment there where they treat one thing a certain way. Taxes you can deduct even though there's no potential sale. Closing costs you cannot deduct. So that was interesting in that case. Next case is Nunes versus Krup. This is out of the fourth DCA. This was one where you got to be careful with settlement negotiations. So this is a this is a husband. It's a divorce. It's a husband texting his wife saying, "Hey, I think our car. I forget what kind of car it was, but I think our car is worth $38,000. I'm willing to negotiate." And so apparently the wife used that text message against the husband in the divorce and said, "Hey, husband, you said the value of the car was $38,000 in your text message." And the court relied on that valuation from the husband, from his own words, to value the car. The appellate court said, nope, can't do that because that's a settlement negotiation. He said it was subject to negotiation, right? He was willing to negotiate further. So that was sort of just like a first shot across the bow of a settlement negotiation. Hey, maybe it's worth $38,000. That's what I think. So you got to be super careful when you're trying to use evidence of a party when they're sort of negotiating between themselves. You can't use it to rely on value if it's a true settlement negotiation. So be careful with that. Next and last case is Magana versus MacHado or MacHado. This is out of the third DCA. And I thought this was just a reminder. If the court fails to make factual findings, you gotta file a motion for rehearing under 12.530, I believe. I'm getting that statute right, or that rule right. You gotta file a motion for rehearing. It's there in the rule now. So the people who are appealing here, they did not file a motion for rehearing. They also did not get a transcript of the trial court proceedings. So they were pretty much out of luck. If you don't have a transcript, you got to show reversible error, clear error from the face of the judgment. And you used to kind of get away with that if there was a failure to make factual findings, but not anymore because now you have to have a motion for rehearing for the failure to make actual factual findings in the judgment. All right, guys. Well, I hope everybody, excuse me, I hope everybody has a wonderful week. Take care, everybody. Disregard that weird line on my face. I think that's from the lighting. All right. Take care, guys. Bye.